Hello. Thank you for joining me. I came inside because it got a little cold outside in front of the school where I'm teaching. I did want to talk to you a little bit more about leasing, suggested lease provisions, and some other information. So, suggested lease provisions that you can really make your lease better with are condition of the premises, tenant's use of the property, and transfer of lease interest. Now, it's not required that you put these in. Remember, we already gone over what is required, but it is a good idea to put these things in to protect yourself as a landlord or a tenant. And so you do want to avoid having unconscionable contract or contracts of adhesion, where a contract is so one-sided as to be terribly unfair, and especially if there's a party who is in superior bargaining position, typically the landlord, and the other party has no way to bargain. There could be issues in some courts about that could cause you problems as a landlord. So you don't want to make your lease so one-sided as to be ridiculous. On the other hand, you can put in some very smart lease provisions as a landlord to help yourself. And tenants need to know anyway some of these things, so it can be helpful to them too to have a very clear lease. So some suggested lease provisions include conditions existing when the lease was made. Does caveat emptor apply? Well, it often may apply in commercial leases, less so in residential leases. So if it's a lease of a house or an apartment, there's typically an implied warranty of habitability, which is an implied promise by the landlord that the law implies that the premises are fit for habitation, that they're livable. So there also, you may want to look at conditions that arise after the tenant takes possession. Who has the risk for that? In common law, the tenant did, but now it's less likely for that to be so. At common law, the landlord had no duty to make repairs, but that has typically changed in most places, especially in the residential area. In the commercial area, there can still be some discussion of that more often than in residential. So basically, under the modern approach, the landlord is responsible for keeping the property in the condition required by housing codes if it's a residential property. Now, in commercial property, there is, in many states, an implied warranty of suitability, which is an implied promise by a commercial landlord that the facilities essential to the use of the commercial premises are free from latent defects and will remain in suitable condition. So it's good to have these lease provisions. If you don't have one, then the tenant can use the property for any legal purpose consistent with the nature of the property and the intention of the parties. So the parties to a lease can and usually should insert a clause in the lease specifying the proposed use of the property, and use the word only residential purposes, only for a restaurant, only for a Chinese restaurant, for example. So oftentimes it's a good idea to put in a clause that provides the commercial tenant may not use the premises in a manner that competes with the landlord's business. In residential leases, it's often common to insert a provision which prohibits tenants from creating a nuisance, bad smells, offensive noise, etc. Also, tenant has the right of quiet enjoyment. They have the right typically to use a property without interference from the landlord, from outsiders, or the government. So I won't go over all of that, but do keep in mind that typical leases will have an insurance that the landlord will not interfere with the tenant's use of the property, and that the tenant will have quiet enjoyment of the property. That's the wording that's normally used. Now, interference by outsiders, there is one area where I wanted to mention. If you own an office building as a landlord and you want to mortgage that office building, well, you may already have tenants there with leases. The mortgage holder, the bank, may be worried about those leases because they were signed and possibly recorded before the bank made their loan and got the mortgage. So the bank does not want to have a situation where they have trouble with foreclosure and collecting rent and all of those other things because of some issue there. So they may come up with a subordination, non-disturbance, and a tournament agreement as part of the requirements for the loan. This means that the tenant would sign saying that the leasehold is lower in priority than the mortgage, and then basically the mortgage holder, the bank would agree that not to disturb the tenant's occupancy under the lease, even if the bank forecloses. So it's kind of a win-win for everybody. It makes the loan go through, and everybody's agreed that the leases can continue after foreclosure, which can be good for the bank as well. All right. Also, if an outsider with no legal interest in the property or an interest inferior to the tenant tries to interfere, the tenant has to take action and can't hold the landlord liable. A tenant is not liable when a lease restricts her to a particular purpose. For example, a casino, and then that purpose becomes illegal as a result of government action, change in law. I did want to mention another thing, assignment and sublease. Don't forget the tenant healthcare case where there was a provision about assignment, and it said assignment will not be approved by the landlord unless, well, how was it? Assignment can be approved by the landlord unless consent is, and consent will not be unreasonably withheld, sorry. And so keep in mind that language of unreasonably withheld. What does that mean? Well, it's not unreasonable to withhold consent to an assignment of a lease when the tenant might do damage or might not pay the rent, the new tenant. On the other hand, the tenant healthcare case said if it's an assignment to a competitor to the landlord, that's not a good enough reason for the landlord to refuse assignment. So again, it's smart to put in the lease if you want to. Whoever is going to be there can't be in the business of the landlord or a competitor of the landlord. An assignment is different from a sublease because the assignment is a lessee's transfer or the tenant's transfer of the entire unexpired remainder of the lease term, which could be like a 1-year lease. Maybe I've been there 2 years. I want to assign you the remaining 10 years. That's how that would work. Now, there are problems here for me, though. So if I'm the tenant or the landlord, but if I'm the tenant and I assign the remaining 10 months of my lease to you, I'm still obligated as the tenant, even though I've assigned the lease to you, unless I get a novation, meaning I get the landlord to assign something saying that it's okay and that I'm released, substituting the new tenant for me. A lot of times landlords won't do it, but if you can get it done, that would take you off the hook. Otherwise, I'm going to still be on the hook. Also, basically, once an assignment has been made, the assigner remains liable only for promises made in the lease, but is not liable for obligations imposed by law. So a grant by a tenant of an interest in a leased property less than she possesses is a sublease. So if I have a 2-year lease and I want to give you 6 months of it in a sublease, and you pay the rent for those 6 months, but then I take it back after the 6 months for the remainder of the 2 years, that's a sublease instead of an assignment. So lease clauses prohibiting assignments and subleases can be a good idea. But you need to be very careful with those as a landlord because courts do try to interpret them narrowly. The law favors the ability to transfer freely, so be careful how you write those and get a good attorney to do it for you. There are several remedies, not just for tenants, but for landlords in this chapter. I won't go over those in this video today. Do review the cases, the Nextel case, the tenant health care, the Mesilla Valley, and the Tracy case about pit bulls and strict liability in Maryland. So I really do appreciate your patience with me as I've traveled, and I appreciate all that you've done as a class. I've enjoyed it very much. I will be back with at least one more video. So I'm not done yet, but I'm getting close. And again, I want to thank you for watching, and I'll talk to you soon.